Surrogacy, IVF, and donor agreements for same-sex couples in New York. Family building for same-sex couples in New York involves joy and complex legal work. The Child Parent Security Act, CPSA, recognizes that intended parents can establish parentage based on consent rather than biology or marriage. Because these protections are not automatic, couples should consult a lawyer who understands both family formation and dissolution. The CPSA legalizes only gestational surrogacy. In this arrangement, an embryo created through in vitro fertilization using gametes from the intended parents or a donor is carried by a surrogate who has no genetic connection to the child. Traditional surrogacy, where the surrogate's own egg is used, remains illegal if compensation is involved and provides no enforceable contract. To protect surrogates and intended parents, the law includes a surrogate's Bill of Rights that ensures the surrogate controls medical decisions and requires separate counsel and adequate health and life insurance. These provisions increase costs but create a reliable framework for determining parentage. For male couples, parentage often relies on 3 documents: an egg donor agreement, a gestational surrogacy agreement, and a judgment of parentage. The donor contract must confirm that the donor relinquishes all parental rights and set out compensation, confidentiality, and disposition of unused embryos. Without clear terms, disputes can arise, and New York courts treat embryos like property and enforce pre-IVF agreements. The surrogacy agreement must be written, signed before medical procedures, and incorporate the surrogate's Bill of Rights. Parents then present a court-issued judgment of parentage so their names appear on the birth certificate. This judgment may be obtained before birth and becomes effective once the child is born. Lesbian couples frequently conceive using donor sperm. Using a donor from a licensed sperm bank is the most secure option because donors sign contracts relinquishing parental rights. Advances in DNA testing make anonymity difficult. The industry calls these non-identified donors. Using a friend or family member without a formal agreement carries significant risk. Without a lawyer-drafted contract, the donor could later seek custody or be liable for support. New York law recognizes that properly executed donor contracts extinguish a donor's rights. The CPSA provides several options for establishing parentage. Couples using assisted reproduction can sign an acknowledgement of parentage to create a legally binding record, but this form is not available in surrogacy cases. A judgment of parentage is mandatory for surrogacy and often recommended for other families because it offers stronger protection and can be obtained before birth. A second parent adoption remains the most secure choice. Although it takes time and requires background checks, adoption decrees must be recognized across state lines under federal law. A knowledgeable attorney can guide couples through these options and ensure documents comply with the law. Listing both parents on a birth certificate does not guarantee recognition in every state. A birth certificate is simply an administrative record. In less affirming states, authorities may refuse to acknowledge a non-biological parent. Choosing the appropriate legal document with the help of an attorney ensures parental rights are enforceable nationwide. Navigating surrogacy, IVF, and donor agreements requires careful legal planning. Juan Luciano, an LGBTQ divorce lawyer in New York City, has represented clients since opening his practice in 2013. Certified to represent both children and adults, he and his law firm provide counsel to families facing complex family law issues and help draft agreements and navigate court orders. The law firm is located at 347 Fifth Avenue, STE 1003, New York, New York, 10016, 212-537-5859. Working with this attorney can give couples confidence that their parental rights are protected.